Hey, welcome to another case law study. So today we're gonna be looking at the case of RYLANDS versus FLETCHER. Actually, this case led to the creation of strict liability, in which even if you don't have any mistakes on your part, you will have to be liable for the act you have committed. So this liability arises when Rylands, the defendant, got a reservoir constructed through independent contractors. The purpose of reservoir is to store a huge amount of water, and there wasn't any confirmation with the neighbor or any other thing. He took this decision on his own. So there was a old unused shaft under the site of the reservoir, which the contractors didn't notice or negligently didn't block it. So when the water filled the reservoir, it burst through the shaft and flooded through the, let's suppose it's the land of Rylands, and this is the land of FLETCHER. FLETCHER has the coal mines in his land, while the Rylands has a huge part of reservoir built for the purpose of storing water. So these shafts were left unnoticed by the independent contractor. Actually, when we look back into the law, it's said that when the independent contractor has been negligent, in some cases the master wouldn't be liable for that completely. But in this case, even if there was an independent contractor being hired, and even though they had been negligent, you will be liable for that. That's the specialty of strict liability. So after some time, the water burst through the old shaft and ran away to the FLETCHER's coal mines. These are coal mines, for instance. I'm sorry, I'm so bad at drawing. So after damaging his property, he had claimed for the compensation, and it has been stated in the code that the person who for his own purposes brings on land, and if there is any hazardous substance kept at it, and if it escapes through his land or the occupation under which the substance has been stored, and the prima facie for all the damages will be natural consequences of its escape. So he might, under this law, be liable for the damage he had caused. For this liability to be applicable, there should be three essentials for this. The one must be he must store any dangerous substances. For instance, let's say water, not dangerous obviously, but when stored in a huge amount, it's definitely dangerous. Electricity. Oh, I'm so bad at writing too. Fumes like fire, flash, or etc. Smoke, or all these stuff, when used in a large amount, can be absolutely dangerous. So the thing that's brought or kept by a person on his land must escape. I mean, it's obvious, right? You wouldn't even be liable if the substance you kept in your land doesn't escape under the land you're in occupation of. So it's so it must be non-natural use of land. Let's suppose if you are having an industry and you are storing a huge amount of bone parts. You're running a bone manufacturing industry, and when it kept closed for, let's suppose, because of the lockdown, and the heap of bones caused many rats to come into your factory, and the rats over there went to the land adjacent to yours and causing damage to the other people's property. Let's suppose if he has some like corn flocks or something which might attract the rats. Yeah, so he can sue you for non-natural use of the land. This liability also comes with 5 exceptions. The first exception is act of God. So you wouldn't even be liable if there is a supernatural, extraordinary force or acting, and it causes damages, and you wouldn't even be liable. Like for instance, tsunami or earthquake, stuff like those. And the second one is plaintiff's own default. So plaintiff, when he voluntarily trespasses into your land and suffers any damages, it's not up to your it's not under your occupation to be even liable for that act. And the third one is plaintiff's own consent. So if you are like having an agreement with your adjacent land owner, like you will be you will be occupying the land for the use of non-natural purposes, and he gives his own consent, then why would you even be liable for that? Because he obviously agreed for that. The fourth one is act of third party. This is obviously known to all of us because you wouldn't even be liable for the act committed by another person, so let's keep it away. The fifth one is statutory authority. For this to apply, you must be under any statute or any legal rights to comply your acts based on the instruction they provide. For example, you are a policeman and then the instruction comes up and you do the stuff they said you to do, so you can obviously commit those acts. So these are the exceptions, and these are the essentials, and this is the judgment they gave. So these statements said that he must be liable for the act which he hadn't even been negligent, or he wouldn't even to cause harm to anybody. So yep, that's it. So this is one of the landmark cases which led to the creation of strict liability based on no fault liability. Right guys, if you enjoyed this video, universal statement, hit the subscribe button and press like. Bye.